Because of California's progressive and important stance in regulating climate change emissions, the federal government's slowness in taking actions, and the belief that the federal government may weaken California protections, environmentalists typically have generally had a presumption that the environment would be better served and protected by allowing California and other states to continue with their own climate change regulation. And this fits with most current environmental control regimes, which generally allow states to go above federal health-based environmental standards if they choose to do so. One notable exception of this, of course, has been the restriction on state deviation from car manufacturing standards, except for, of course, the California exception. Well, I come to this by asking a question of whether we can learn anything from the history of environmental federalism between the states and the federal government, and then possibly some other areas of state-federal preemption issues that can give us some clues for what might appropriately be best for exclusive control at the federal level. So I'm coming at this by saying, should the federal government preempting climate change? Is that ever good? Is that ever a possibility? Briefly, I'm just going to talk about certain factors to consider in preemption. I'm going to give a particular focus to environmental protection and economic efficiency as factors, look at preemption in prior environmental law, preemption in other laws, and then some lessons that we can draw from that. The preemption factors are the following, as I define them. What should we consider when we're trying to determine issues of whether or not there should be preemption from a policy matter? Note, I'm leaving the legal implementation to a later point. Before we even decide what the statute should look like, or savings clauses, or what might happen, we really need to decide what we want to have happen. And the factors that I think we should consider are public choice policies and political theory, the kinds of government gamesmanship issues. And in this case, the environmental protection that results from the policy, the economic costs and efficiency of the policy, and of course, the issue of sovereignty, because that's very critical in our concept of preemption. I'm particularly going to look at two of these today. The environmental protection reasons that we may or may not want preemption, and the economic costs and efficiency reasons that we may or may not want this. I also want to look briefly at mitigation and adaptation, and I'm going to explain that momentarily. Let me just define some key terms first. Federalism, I think we all know. Preemption, we've been talking about, but there's something called a floor preemption and a ceiling preemption. I give credit to Bill Busby for bringing this out into the open and discussion in academia. The concept of floor preemption is that the federal government sets a minimal standard, and states may go above that standard. The concept of ceiling preemption is the federal government sets a ceiling standard, and states cannot go above that standard. They may go below, but not above. And of course, you could have a uniform standard, which is both a floor and a ceiling. Climate change mitigation policy is generally what we've been talking about today and so far. That is that we want to talk about policies that mitigate the greenhouse gas buildup in the atmosphere. But there's also something else that's going to be equally important in discussing federalism, and that's climate change adaptation policy. That is a policy in which we adapt our environment, our laws, our systems to the effects that are going to come about from climate change. So let's think about this in terms of a background before we move on. We're dealing with climate change preemption and the background of California's AB 32, which you've heard a great deal about, and which we're very lucky to hear from Chairman Nichols about. But it's not just California. We also have other states that have moved into the breach, some economy-wide like Washington State, and others in more limited trading initiatives or other restrictions. And this is taking place in the context of proposed federal legislation. And two I want to talk about in particular. The Lieberman-Warner-Boxer bill, which may have a different title this time around, the Climate Security Act of 2007, 2008, et cetera, it says that there is no preemption, right? It actually takes the route that states should not be preempted in their approach to climate change. And Barbara Boxer has made this a very important point of what she wants to see in a Senate bill. However, as Bill pointed out very correctly, even if a statute says no preemption, that doesn't mean that preemption won't come about through judicial interpretation or other conflict legislation. The Dingell-Boucher bill, on the other hand, as Lori pointed out, does have some preemption language. Not complete preemption, perhaps, but some preemption language. I put at the bottom of this something called the simplified version, based on Chairman Waxman and Senator Boxer's call for perhaps a federal bill that would be simplified from the 200 to 600 page bills that are circulating now. Why is that going to be important? Well, to the extent it talks less and less about preemption, even if it doesn't explicitly preempt, we run more of the risk of what Bill was discussing of having the judiciary or administrative agencies come in and move preemption. So all of this policy discussion is on the background of what's happening in California, proposed federal bills, what might happen in federal bills, what that language might be. Let's look at some facts about this preemption and climate change. I think we all know, and we discussed this last night, that the preemption issue in some ways is probably pushing the federal legislation. Certainly, one of the reasons we first had a call for federal legislation was, oh, goodness, we can't have all the states doing all these different things. Let's have federal legislation. So the preemption is related to the fact that we're discussing federal legislation at all. Without legislation, the Clean Air Act will probably be brought in to regulate in the climate change arena. And there's no preemption there, no ceiling preemption, except for fuel economy because of the California standard. So that's another factor. If we don't have federal legislation, what are we going to have? We're going to have some implementation with the Clean Air Act, which will preserve floor preemption and presumably would have no ceiling preemption. There are also concerns over fuel economy and the concerns over the subjection to multiple cap and trade, and we'll talk about that as a factor momentarily. And then the Democratic administration in Congress clearly has already made a difference, and that fact on the ground is going to make a difference in how we come to the conclusion on this. But there are other issues as well. We talk a lot about climate change, cap and trade, but we have to look closely at some other things, and Bill started listing some of these. Energy efficiency standards, building codes, land use patterns, electric power regulation. These don't have as much attention as the debate about preempting a cap and trade, say in California, but they're very important. And ultimately, down the line, what actually may make a lot of difference are these other policy factors that are not often thought about as sort of environmental legislation per se, but clearly are important in terms of cap and trade. Well, what about the history of preemption in environmental law? What can we glean from that? Just some brief things. In the Clean Air Act, we have preemption in setting the command and control standards, but the states can exceed that. So it's a floor preemption. That is, under the state implementation plan, they can add additional requirements to their stationary sources if they need to. There's also preemption in setting the ambient standards at the federal level, both a floor and ceiling, but again, the states can choose to exceed that if they choose to do so. So, excuse me, not a ceiling. The Clean Air Act does not allow, and this was explicitly determined in 1977, and a point I want to emphasize, it explicitly prohibits the federal government from preempting land use controls. Originally, when the Clean Air Act came into being, it was obvious that to control mobile sources, one of the best ways to do that is to control these indirect locational sources where cars drive, right? Housing, development, growth patterns. And initially, the states and the EPA said, well, we're going to try and make the states adopt these things for their state implementation plans. And in 1977, Congress said no. That was taken off the table. In the Clean Water Act, we have preemption, again, floor preemption in setting effluent standards, but again, the state can exceed. And even there, the floor preemption is a little dicey because of various provisions of how the state comes up with its standard setting in general. Also in the Clean Water Act, there are proposed land use practices, but the state flexibility is allowed to meet them, although they're supposed to, of course, meet federal standards as they move on.
Victor, 5 minutes.
Thank you. Also, the Endangered Species Act state an additional. Preemption in other areas, I'm just going to go through this briefly. I'm just going to put these up because these are all areas that have had preemption discussions recently and have some interesting lessons to give us. What those lessons are, I'm going to still discussing each of them separately in the interest of time. I'll come back to in the lessons. But just noted that we have had preemption in these areas for various reasons. For instance, in civil rights, it's because of the ability of the federal administrative infrastructure to do this. We also have floor preemption, ceiling preemption arguments as well.